Hello, my name is Thomas Scott, and this is the Week 1 reading from Business 280 Business Law. I'm recording this for audio learners like myself who find it hard to sit and read the book and prefer to listen instead. Also, it's possible to speed up the audio, skip to certain sections, and review. I don't read any of the summaries or any of the extra things on the side. I just kind of stick to the meat, and you're welcome to go back and review all the extra potatoes and all that stuff on your own time. But this will help you just like either play before bed or as you're working on something else with your hands, like I like to do, multitask. This is a good way to get it kind of just imprinted in your brain one way or another. Thank you.
Chapter 1 begins on page 4 with Nature of Law and Legal Rights. Why have law? If you have ever been stuck in a traffic jam or jostled in a crowd leaving a stadium, you have observed the need for order to keep those involved moving in an efficient and safe manner. The issues with bloggers, use of others' materials, and continuing downloading of music and films without compensation to copyright holders illustrate the need for rules and order in this era of new technology. When our interactions are not orderly, whether at our concerts or through our email, all of us and our rights are affected. The order of or pattern of rules that society uses to govern the conduct of individuals and their relationships is called law. Law keeps society running smoothly and efficiently. Law consists of the body of principles that govern conduct and that can be enforced in courts or by administrative agencies. The law could also be described as a collection or bundle of rights. Legal rights. A right is a legal capacity to require another person to perform or refrain from performing an act. Our rights flow from the U.S. Constitution, state constitutions, federal and state statutes, and ordinance at the local levels, including cities, countries, and boroughs. Within the sources of rights are also duties. A duty is an obligation of law imposed on a person to perform or refrain from performing a certain act. Duties and rights coexist. No right exists in the one person without a corresponding duty resting on some other person or persons. For example, if the term of lease provide that the premises will remain in a condition of good repair so that the tenant can live there comfortably, the landlord has a corresponding duty to provide a dwelling that has hot and cold running water. Individual rights. The U.S. Constitution gives individuals certain rights. Those rights include the right to freedom of speech, the right to due process, or the right to have a hearing before any freedom is taken away, and the right to vote. There are also duties that accomplish individual rights, such as the duty to speak in a way that does not cause harm to others. For example, individuals are free to express their opinions about the government or its officials, but they would not be permitted to yell fire in a crowded theater and cause unnecessary harm to others. The rights given to the U.S. Constitution are rights that cannot be taken away or violated in by any statutes, ordinances, or court decisions. These rights provide a framework for the structure of government and other laws. The right of privacy. One very important individual legal right is the right of privacy, which has two components. The first is the right to be secure against unreasonable searches and seizures by the government. The Fourth Amendment of the U.S. Constitution guarantees this portion of the right of privacy. A police officer, for example, may not search your home unless the officer has a reasonable suspicion, which is generally established through a warrant, that your home contains evidence of a crime. Let me read that. A police officer, for example, may not search your home unless the officer has a reasonable suspicion, which is generally established through a warrant, that your home contains evidence of a crime such as illegal drugs. If your home or business is searched unlawfully Any items obtained during the unlawful search could be excluded as evidence in a criminal trial because of the Fourth Amendment's exclusionary rule. For example, in Riley v. California, 134 Street Court Count 2473, David Riley was stopped by a police officer for driving with an expired registration tags. The officer discovered that Mr. Riley's license had been suspended, so his car was impounded and searched. Page 5. Officers also found Mr. Riley's smartphone and, in going through the phone, found pictures and information related to a gang shooting. And Mr. Riley was then charged with that earlier shooting. However, the court held that evidence from the smartphone could not be used in the trial because there was no warrant, and Mr. Riley had a right of privacy in the data on that phone. A second aspect of the right of privacy protects individuals against intrusion by others. For your private life is not subject to public scrutiny when you are a private citizen. This right is provided in many state constitutions and exists through interpretation at the federal level. Through the landmark case of Roe v. Wade, in which the U.S. Supreme Court established a right of privacy that gives women the right to choose whether to have an abortion. These two components of the right to privacy have many interpretations. These interpretations are often found in statutes that afford privacy rights. With respect to certain types of conduct, these interpretations are often found in statutes that afford privacy rights with respect to certain types of conduct. For example, a federal statute provides a right of privacy to bank customers that prevents their banks from giving out information about their accounts except to law enforcement agencies conducting investigations. Some laws protect the rights of students. For example, the Family Education Rights and Privacy Act of 1974, aka FERPA, also known as the Buckley Amendment. This prevents colleges and universities from disclosing students' grades to third parties without the student's permission. From your credit information to your social security number, we have great privacy protections. Privacy and technology. Technology creates new situations that may require the application of new rules of law. Technology has changed the way we interact with each other, and new rules of law have developed to protect our rights. Today, business is conducted by computers, wire transfers of funds, email, electronic data interchange, EDI, order placements, and the internet. We still expect that our communication is private. However, technology also affords others the ability to eavesdrop on conversations and intercept electronic messages. The law has stepped in to reestablish that the right of privacy still exists even in those technologically non-private circumstances. Some laws now make it a crime and a breach of privacy to engage in such interceptions of communications. There's a case summary that follows. For an example, I will not be reading that. I'm sticking to the next page. Page 6. There's many examples here. One's ethics in the law, which is a LinkedIn example, an example of maybe to LinkedIn. It says e-commerce and cyber law example here. Next page. Page 7. Sources of law. Several layers of law are enacted at different levels of government to provide the framework for business and personal rights and duties. At the base of this framework of laws is the constitutional law. Constitutional law. Constitutional law is the branch of law that is based on the Constitution for a particular level of government. A constitution is a body of principles that establishes the structure of government and the relationship of that government to the people who are governed. A constitution is generally a combination of written documents and the practices of and customs that develop with the passage of time and the emergence of new problems. In each state, two constitutions are in force: the state constitution and the federal constitution. Statutory law. Statutory law includes legislative acts. Both Congress and the state legislative enact situational law. Examples of congressional legislative enactments include the Securities Act of 1933, which is in Chapter 45, the Sherman Antitrust Act, which is located in Chapter 5, the Bankruptcy Laws, Chapter 34, and the Consumer Credit Protection Provisions, Chapter 32. At the state level, statutes govern the creation of corporations, probate of wills, and the transfer of title to property. In addition to the state legislatures and the U.S. Congress, all cities, countries, and other government subdivisions have some power to adopt ordinances within their sphere of operation. Examples of the types of laws found at this level of government include traffic laws, zoning laws, and pet and bicycle licensing laws. Administrative law. Administrative law regulations are rules promulgated by state and federal federal administrative agencies such as the Securities and Exchange Commission, SEC, and the Environmental Protection Agency, the EPA. For example, the restrictions on carbon emissions by businesses have all been promulgated by the EPA. These regulations generally have the force of statutes. Private law. Even individuals and businesses create their own laws, or private law. Private law consists of the rules and regulations parties agree to as part of their contractual relationships. For example, landlords develop rules for tenants on everything from parking to laundry room use. Employers develop rules for employees on everything from proper computing use to posting pictures and information on bulletin boards located within the company walls. Homeowners associations have rules on everything from your landscaping to the color of your house paint. Case law, statutory interpretation, and precedent. Laws also include principles that are expressed for the first time in court decisions. This form of law is called case law. Case law plays three very important roles. The first is one of clarifying the meaning of statutes or providing statutory interpretation. For example, in King v. Burwell, the U.S. Supreme Court interpreted the phrase The U.S. Supreme Court interpreted the phrase, page 8. The U.S. Supreme Law interpreted the phrase established by the state in the Affordable Care Act to determine whether tax credits were available to insurance exchanges operated by the federal government and not the states. The court held that state meant either the federal government or any of the states so that all exchanges qualify for the tax credits. The second role that courts play is in creating precedent. When a court decides a new question or problem, its decision becomes a precedent, which stands as the law in future cases that involve that particular problem. Using precedent and following decisions is also known as the doctrine of stare decisis. However, the rule of stare decisis is not cast in stone. Judges have some flexibility. When a court finds an earlier decision to be incorrect, it overrules that decision. For example, in National Federation of Independent Business versus Sebelius, 132 S. Court CT 2566 2012, the U.S. Supreme Court held that the Affordable Care Act, Obamacare, was constitutional. However, in 2014, the court held, based on new issues raised, that the portion of the act violated the First Amendment because it mandated health coverage of certain types of birth controls that were in violation of the religious beliefs of the owners of a corporation. Burwell versus Hobby Lobby Stores Incorporated, 134 S. CT 2751 2014. The third role courts play in developing a body of law is not statutory but addresses long-standing issues. The third role courts play is in developing a body of law that is not statutory but addresses long-standing issues. Court decisions do not always deal with new problems or make new rules. In many cases, courts apply rules as they have been for many years, even centuries. These time-honored rules of the community are called the common law. For example, most of the law that we still follow today is determining real property rights developed in England. For example, most of the law that we still follow today in determining real property rights developed in England, beginning in 1066. Statutes sometimes repeal or redeclare the common law rules. Many statutes depend on the common law for definitions of the terms in the statutes. Other forms of law, treaties, and executive orders. Law also includes treaties made by the United States and proclamations and executive orders of the President of the United States or of other public officials. President Obama's executive order altering immigration policy is a subject of a constitutional challenge to the scope of executive orders. Uniform state laws. To facilitate the national nature of business and transactions, the National Conference of Commissioners on Uniform State Laws, the NCCUSL, composed of representatives from every state, has drafted statutes on various subjects for adoption by the states. The best example of such laws is the Uniform Commercial Code, the UCC. See chapters 22 through 30 and chapter 33. The UCC regulates the sale and lease of goods, commercial paper such as checks, fund transfers, secured transactions in personal property, banking, and letters of credit, having the same principle of law on contracts for the sale of goods and other commercial transactions in most of the 50 states, makes doing business easier and less expensive. Other examples of uniform law across the states include the Model Business Corporation Act, which is located in Chapter 43, the Uniform Partnership Act, Chapter 41, and the Uniform Residential Landlord-Tenant Act, Chapter 50. The Uniform Computer Information Transactions Act, UCITA, as well as the Uniform Electronic Transactions Act. It's a mouthful. Continuing on page 9, as well as the UETA, are two uniform laws that have taken contract law from the traditional paper era to the paperless computer age. This is page 9, which continues on to classifications of law. Section 1.3, classifications of law. Substantive law versus procedural law. Substantive law creates, defines, and regulates rights and liabilities. The law that determines when a contract is formed is substantive law. Procedural law specifies the steps that must be followed in enforcing those rights and liabilities. For example, once that contract is formed, you have rights to enforce that contract, and the steps you take through the court system to recover your damages for a breach of contract are procedural laws. The laws that prohibit computer theft are substantive laws. The prosecution of someone for computer theft follows procedural law. Criminal law versus civil law. Criminal laws define wrongs against society. Civil laws define the rights of one person against another. Criminal law violations carry fines and imprisonment as penalties. Civil laws carry damage remedies for the wronged individual. For example, if you run a red light, you have committed a crime. And if you run a red light, you have committed a crime and will be punished with a fine and points on your license. If you run a red light and strike a pedestrian, you will also have committed a civil wrong of injury to another through your You've also committed a civil wrong of injury to another through your carelessness. Civil laws provide that in addition to taking care of your wrong to society, you must take care of your wrong to the pedestrian and pay damages for the cost of her or his injuries. See Chapter 8 for more information about recovery of damages for accidents such as this. We're on page 10. Law versus equality. Law versus equity. Equity is a body of law that provides justice when the law does not offer an adequate remedy or the application of the law would be terribly unfair. Equity courts develop Equity courts developed in England as a means of getting to the heart of a dispute and seeing that justice was done. For example, Christian Louboutin shoes have a distinctive red bottom that is their trademark. Vieux Saint Laurent began producing its shoes with a red bottom. Common and statutory law provide for Louboutin to collect damages. The amount the company lost in sales through the copycat efforts of Vieux Saint Laurent. However, Vieux Saint Laurent began producing its shoes with a red bottom. Common and statutory law provide for Louboutin to collect damages. The amount the company lost in sales through the copycat efforts of Vieux Saint Laurent. Okay, let me start that over. For example, Christian Louboutin shoes have a distinctive red bottom that is their trademark. Vieux Saint Laurent began producing its shoes with a red bottom. Common and statutory law provides for Louboutin to collect damages. The amount the company lost in sales through the copycat efforts of Vieux Saint Laurent. However, if the Vieux Saint Laurent shoes continue in production, Louboutin is never adequately compensated. Equity provides for an injunction, a court order to stop Vieux Saint Laurent from making the red-soled shoes. At one time, the United States has had separate law courts and equity courts, but today these courts have been combined so that one court applies principle of both law and equity. A party may ask for both legal and equitable remedies in a single court. For example, suppose a homeowner contracts to sell his home to a buyer. If a homeowner then refuses to go through with the contract, the buyer has the legal remedy of recovering damages. The rules of equity go further and could require the owner to convey title to the house An equitable remedy known as specific performance. The rules of equity go further and could require the owner to convey title to the house. An equitable remedy known as specific performance. Equitable remedies may also be available in certain contract breaches. See chapters 2, 11, and 19. Okay, this is the end of the chapter, so I'm going to go ahead and read the summary they provide. Make the connection. Summary. Law provides rights and imposes duty. One such right is the right of privacy, which affords protection against unreasonable searches of our property and intrusion into or disclosure of our own private affairs. Law consists of the pattern of rules established by society to govern conduct and relationships. These rules can be expressed as constitutional provisions, statutes, administrative regulations, and case decisions. Law can be classified as substantive or procedural, and it can be described in terms of civil or criminal law. Law provides remedies in equity in addition to damages. The sources of law include constitutions, federal and state statutes, administrative regulations, ordinances, and uniform laws generally codified by the states in their statutes. The courts are also source of law through their adherence to case procedure under the doctrine of stare decisis, and through their development of time-honored principles called the common law. You have on page 11, you have learning outcomes, which looks like a discussion questions, basically key terms to go over, questions and case problems. Looks like a lot of basically summary, more summary items. And that goes on through page 12, basically another way to recap the chapter yourself. Chapter 2 starts on page 13. And that was it for chapter 1.